Okay, now for our next video vignette associated with the Kentucky Realtors Statewide Contract, we're going to talk about paragraph 4 in the earnest money deposit. Now this one won't take as long as the last vignette, but it is important, and it is one that we get a lot of questions about on the Kentucky hotline. And we're going to look at paragraph 4. It's titled Earnest Money Deposit. It begins on line 68 and goes to line 79. Remember, that's running along the left-hand side of the numeric numbers running along the left-hand side of the contract. So let's start out at paragraph 4. And the first sentence is, the earnest money deposit shall be delivered by buyer or buyer's agent within 3 days and shall be held in the escrow account of blank. Well, that sentence seems pretty simple, but there's a lot of things I want to talk to you about in it. So first of all, what is the earnest money deposit? Well, we've already said that is the buyer's effort, supposedly, to show their earnestness toward completion of the purchase price. So the higher that number is, by definition, it would imply that they are more earnest about completing the contract. The lower that number is, the less willing they seem to put at risk toward the purchase. So a high earnest money deposit would be attractive to a seller. A low earnest money deposit would be less attractive. And why I say that is because that means it becomes a material term. So failure to do something with regard to the earnest money deposit won't just be ignored. A court would look at that and say, no, a court or an arbitrator would look at that and say, no, this is a material term, this is important. Therefore, the duties associated with that are important. So again, we go back to that first sentence. The earnest money deposit shall be delivered by buyers or buyer's agent within 3 days. Okay, now you're going to hear 3 days twice as it relates to this sentence. The first one I'm going to call the contractual 3 days. So this contract requires either the buyer or the buyer's agent to deliver the earnest money to the broker who is supposed to hold the escrow account, not to their own broker alone necessarily. Because once the broker who's supposed to hold that money in their escrow account gets that money, they, according to statute, have to put that money into their escrow account within 3 days. So the first 3 days is a contractual requirement, and that is the requirement that the buyer or the buyer's agent give that earnest money to the principal broker, whichever one he does, meaning whether it be the listing broker or whether it be the selling broker. They have to put that deposit within their hands within 3 days. And then there's a statutory requirement that that broker, whichever one it is, then has to put that deposit in their escrow account within 3 days. Now, if you look at your handy Kentucky Real Estate Manual that's provided recently been created by the Kentucky Realtor Institute, it has that right here, and that is in KRS 324111. And it says in 324111 section 1 that they've got to put that money in there without unreasonable delay, and unreasonable delay is defined as 3 days. So let's talk about that. First of all, if these things don't happen, you have a potential contract breach, and then you have a potential statutory breach. So let's first deal with the contract breach. If the buyer or the buyer's agent does not deliver the deposit to the principal broker that's supposed to get it, and that broker can be the listing broker, or that broker potentially could be the selling broker. If that earnest money deposit is not delivered within that time frame, then the buyer is in breach. Now, if the buyer is in breach because they didn't deliver it, that means arguably that the seller could arguably be excused from performance, and that the buyer may be responsible for the payment of the commissions of both agents and brokers without ever even receiving the property. So it is a very dangerous thing for the buyer to submit an offer without first, at the same time, handing the buyer's agent the check. Now let's go to the second point of this. Let's imagine that the contract says that the money must go to the listing broker. Well, if the buyer's agent gets the check from the buyer and then doesn't deliver it to the listing broker within that 3 days that's set forth within the contract, then the buyer's agent has put the buyer in breach, which means the buyer has liability, but now so does the buyer's agent to its buyer because they were negligent in their performance of their duties. So this becomes very important. Now, I hear sometimes people say something to the effect of, well, that contract didn't count or was voided because I never delivered the earnest money deposit. That's not true. And let me emphasize that as much as I can. That is absolutely not true. Your failure to deliver the deposit doesn't mean you don't have to perform under the contract. Your failure to deliver the deposit as the buyer means that you're in breach of the contract. The contract is still into effect. So you need to be very careful in understanding that. Now, that's how it works with this contract. There may be another contract out there that says it's contingent upon receipt of the deposit. I've not seen that one. Most every one I have seen have always made it a requirement to deliver it, not this contingency that kind of floats around. So again, it's very important. Now, let's go to the other part of that sentence, and that is who gets to hold the deposit. Well, as the buyer's agent, the selling agent, you would prefer, and your buyer would prefer, that that money go into the hands of the buyer's broker / selling broker. And you may say, well, Jason, why would that be? Well, if we go back to our manual and we look at 324111 subsection 6, you're going to note that if a dispute arises, there are a few ways to which that check can be released by the broker that's holding that deposit. Now, that is, among one thing, is that a written agreement between the parties. And if there is no written agreement between the parties and there is no court order, then 324111 subsection 6 says that after the broker sends out the 60-day warning letter, the broker that's holding that deposit may, it's an option, may decide who they're going to send that deposit to. Well, now think about this. Who do you think the buyer's broker is more likely to send the deposit to? The buyer or the seller? I would say that 95% of the time, they're going to send it back to the buyer, which means as the buyer's agent, you want to put it or you want to require it to go into the buyer broker account. Conversely, if you're receiving an offer and the earnest money deposit is important to your client, meaning that they really want to make sure that shows the buyer's commitment to the transaction, then you want to say, no, that money goes into the hands of our broker, the listing broker, because they will ultimately control, if a court order doesn't or there's not a written agreement, they will ultimately control where that deposit goes. And again, if it's in the listing broker's hands, who do you think they're going to send it to? They're going to send it to their seller. All right. Now, just in case you were doubtful about my statement that this is a breach of contract if you don't deliver the earnest money deposit, the very next sentence clears it up because it says failure to deliver the earnest money deposit within the aforementioned time period shall constitute a breach of this contract. Now it goes on to say, in which case the seller may either A, grant a written extension of time, B, void the contract, or C, pursue a claim for damages as a result of the breach. So there is no question that that is a breach. Now it goes on to also say that deposit shall only be removed from the broker's escrow account upon closing, written agreement of all the parties, court order, or as provided by law. And again, when we're talking provided by law, we're looking at 324.111 subsection 6 of the KRS. Now, if either party fails to perform his or her obligations hereunder, the other party may accept the deposit as liquidated damages, with both parties signing a release, or subject to paragraph 26, may pursue any available legal or equitable remedy. Now, what does liquidated damages means? That means that you can just take the earnest money deposit, you're done, and you just move on. That's all you get. Now, you're not limited to that. So let's say the buyer doesn't deliver the earnest money deposit and they want to accept that as part of their, or they do deliver the earnest money deposit and they want to accept that as their liquidated damages, they can, or they can go and pursue for any number of remedies, consequential damages, punitive damages, all of those other things. Now, in the event that any legal action is necessary as a result of the buyer or seller's refusal to release the earnest money deposit, the prevailing party shall be entitled to recover, in addition to any other remedies under this contract, the earnest money deposit, the mediation and arbitration or court costs, and the reasonable attorney's fees required to obtain recovery of said deposit, not to exceed 3 times the deposit amount. So let's kind of unpack that kind of complicated sentence. What does this mean? This means that, let's say there is a $5,000 deposit and that the buyer put that down. It's in the hands of the listing broker, and the buyer at some point, their financing doesn't work out. And there was a financing contingency. But let's imagine that the seller is upset and just says, no, I'm not authorizing you, listing broker, to release that money. I'm not going to sign a release. No real reason other than the seller's angry. Well, it used to be that really put the buyer in a tough position. It put the broker in a tough position because trying to legally maneuver this was tough. The listing broker's sitting there going, I think the buyer's right, but I don't want to offend my client. The buyer's going, I want my $5,000, but it's going to cost me more than that to go through mediation and arbitration and then to pay my attorney to do this. So there was a provision that said if in that situation the buyer says, I want my $5,000, and the buyer legitimately was able to utilize the contingency on financing, for example, then in order to get that money back, the buyer should be able, if they win the case, to get their deposit back, to get their mediation and arbitration costs paid for, and to get their attorney's fees paid for up to 3 times the deposit amount. So which in this case would be $15,000. So if the buyer had to go to court, had to enforce this, had to hire an attorney, and won, the $5,000 return of the earnest money deposit would no longer be sufficient. It would now be up to the potential of $20,000, and even beyond that, because the mediation arbitration costs could exceed that amount. So that is a high cost for just being angry about the transaction, and that would be a cost the seller would ultimately have to pay. So keep in mind, it's not just as easy in this contract to just say you're not going to return the earnest money deposit. There are some real financial detriment and damage that could occur if you do that. Now, the last sentence says this limitation on the damages recoverable is for claims based on the failure to release the deposit, and it shall not limit the recovery of damages based on any other claim. So you may also be suing over breach of contract or some other theory or fraud or what have you, and then also suing on this earnest money deposit issue. They are 2 separate things. So you may be able to recover on both. Now, the important thing to remember on paragraph 4 is that you must deliver that earnest money deposit within 3 days, and that the selection of who the broker is that's going to hold that money is very important. And at a minimum, you should make sure you discuss the import of that decision with your clients, whether they be the buyer or whether they be the seller. Hopefully this video vignette is helpful and will help you continue to work through and utilize the Kentucky Realtors statewide contract.